This is Richard Thorpe, Chair of Panel B. We're calling Panel B. We're very grateful for all of our attendants, the administrative law judge and our legal counsels, and for Dr. Eng and his counsel to be here in person today. We appreciate that you are here in person today. This is really the only item that we have on the agenda today, Dr. Eng's in-person testimony. And so we will not take any further time and begin that proceeding. At this point, then, I will turn it over to the Honorable Van Rooyen, and I'll allow him to proceed with his consideration.
Dr. Thorpe, this is Michelle Angus speaking.
Hi, Michelle.
Before we do that, good morning. Before we do that, would you mind taking roll and confirming we do have a quorum?
I apologize. I just assumed we'll call the meeting to order by calling the roll.
Thank you.
All right. So we're starting the roll call here. Do I have Dr. Thorpe?
Here.
Dr. Hessler?
Here.
Ms. Lawson?
Here.
Dr. Mahmood?
Yes.
All right, we have a quorum.
Okay. Now it's up to you, Judge.
Thank you very much, Dr. Thorpe. And I just wanted to check, Ms. Zhang also appeared on the schedule, but she's not present today. I just want to make sure I got that right. We have just 4 board members, is that correct? Vang, is that correct? Sorry, I'm not sure if people can hear me.
Yes, that's correct.
All right. Okay. Thank you so much. I just didn't want to miss anyone later on. All right. Perfect. And let me make sure we have the Deputy Attorney General on. You can still hear me, Ms. Carroll, correct?
I can. Is everyone, including the board member, are they all able to hear me?
Dr. Thorpe, can you hear Ms. O'Carroll?
Yes, I can hear it. It does help to speak distinctly and somewhat slowly, because the more rapid you speak, it gets blurred. But it's probably just my bad hearing. That's probably the problem.
Understood.
All right. And then, Mr. Firestone, can you hear us?
Yes, I can, Your Honor.
Wonderful. Thank you so much. I will try to speak up as much as I can and slowly. Thank you, Dr. Thorpe. Madam Court Reporter, you have your hand up.
Yes. The only trouble I might have is when we get to questioning by any board members, since I can't make them out individually, they're all in the room, if they could state maybe their names so I could distinguish who's speaking, that would be great.
Yes, and I will call on them individually so that you'll know who's asking a question. That's how
Fabulous. Thank you so much. I'm ready when you are.
All right, let's go on the record, everyone. All right, we are on the record before the Medical Board of California, Department of Consumer Affairs, State of California. We're here in the matter of the accusation that was filed against Gan Zhong-Ng, which is spelled Ganxonng, MD. This is Physician's and Surgeon Certificate number C53500. Medical Board of California case number is 800-2019-062389. The original OAH case number is 2023-020-727. And the OAH case number that was set for today's oral argument is 2024-010-890. Today is February 29th, 2024. It's approximately 9:10 a.m. This matter was set for hearing at 9 a.m. This is the date and time that was set in the notice of hearing for oral argument. We are conducting the oral argument in person and by WebEx video conference. My name is Wim van Rooyen, spelled W-I-M space V-A-N space R-O-O-Y-E-N. I'm an administrative law judge with the Office of Administrative Hearings, and I've been assigned to preside over the oral argument today. First, although I know we've already taken a roll call earlier, that was not on the record, so I'm going to ask each of the panel members to identify themselves for the record. Panel B, starting with you, Dr. Thorpe, please.
Richard Thorpe, here.
Thank you. Dr. Hiltzer?
James Helzer.
Good morning to you. And Ms. Lawson?
Christina Lawson here.
Thank you. And Dr. Mahmood?
Dr. Asif Mahmood.
Thank you very much. I do find that there's a quorum present. And for the court reporter, the names are spelled Richard Thorpe, Richard R-I-C-H-A-R-D, Thorpe T-H-O-R-P, Heltzer, James Heltzer, J-A-M-E-S, Heltzer, H-E-A-L-Z-E-R, Christina Lawson, K-R-I-S-T-I-N-A, Lawson, L-A-W-S-O-N, and Asif Mahmood, A-S-I-F, M-A-H-M-O-O-D. Now, may I please have formal appearances from counsel, please, starting with the Deputy Attorney General.
This is Megan O'Carroll of the California Attorney General's Office on behalf of complainant, the Medical Board of California.
Good morning to you, Ms. O'Carroll, and then on behalf of the respondent.
Good morning, Your Honor, and to the board members. This is Michael Firestone on behalf of Dr. Eng, who is also here.
Good morning, Mr. Firestone, and good morning, Dr. Eng. Thank you so much. So the board has issued an order of non-adoption of the proposed decision by an ALJ in this matter and has set this matter for oral argument before the board's panel B. The following process and time limitations will apply. First, the respondent will have 15 minutes to make an opening argument. Following that, the Deputy Attorney General will have 15 minutes for her opening argument. After that, the respondent will have 5 minutes for a closing argument. And then after that, the Deputy Attorney General will also have 5 minutes to make a closing argument. These time limits will be strictly enforced. The arguments shall be based only on the existing record and shall not exceed the scope of the record of duly admitted evidence. No new evidence will be heard. The panel members may ask questions of the parties to clarify the arguments, but may not ask questions that would elicit new evidence. Either I or any panel member may ask a party to support the party's oral argument on a matter with a specific citation to the record. At the end of the oral argument by counsel, I will offer the respondent physician an opportunity to address the panel. If the respondent elects to address the panel, I will place the respondent under oath. Now, my understanding is there was a request, Mr. Firestone, to have the physician be sworn in earlier and testify as part of your 15 minutes of argument at the beginning. Is that correct?
The reason I was making that request is because I did not anticipate Dr. Eng having an opportunity to give a statement. I thought he was only allowed to answer questions, but we had planned on having us share the 15 minutes time frame for me to make an oral argument and then him to make a statement as well.
All right, so are you satisfied with him addressing the panel in the usual time, or are you still requesting, because again, he will have an opportunity at the end to address the panel, and then they will have an opportunity to ask him questions. But did you still want to cede part of your 15 minutes at the beginning, or have him address them at the end?
I think it would be better the way we've planned it to do the shared of the 15 minutes, if that's okay.
That's fine, as long as you understand that that will count towards the 15 minutes of your argument. So I mean, essentially you're cutting into your own time a little bit, which is fine by me. I just want to make sure that that is what you're requesting.
Yes.
All right, thank you very much. Ms. O'Carroll, do you have any objection to that?
No, Your Honor.
Thank you very much. All right. So I will swear him in at the beginning of your argument, and then you can share the initial 15 minutes as you choose. And then at the end, I will have the board members ask him questions if they have any. But he won't have another opportunity to address the panel at that time. A court reporter is present to record the proceedings. After oral argument, the board will go into a closed session to deliberate. The parties will not receive a decision today, but will be receiving it in the mail sometime in the future. Again, please remember that all arguments must be based on the existing record and no new evidence will be heard. As a reminder, the board has already had the benefit of reading your briefs. So with that said, we can start with the oral arguments. Respondent will go first, as I mentioned. So Dr. Ng, if you can step up, I just want to swear you in. Can you please raise your right hand for me? Do you solemnly state under penalty of perjury that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
I do.
Could you speak up slightly, sir? I didn't hear
I
the
do.
I don't think the court reporter did either.
I do.
Thank you very much. Now you can put your hand down and be seated. Thank you so much. Mr. Firestone, I'm going to start your 15 minutes now, and as I said, you can share that as you wish with Dr. Ng. Starting now.
Good morning, esteemed members of the Medical Board of California. I'm Michael Firestone, and I'm honored to represent Dr. Ng in this matter and speak with you all today. To allow Dr. Ng time to speak, I'll be brief. First, I'd like to highlight a subtle inconsistency in the board's order of non-adoption because it gets to the heart of the issues in this case and the issue before the board. The board's order of non-adoption states that written argument is to be directed at whether the level of discipline ordered is sufficient to protect the public, but then later states that oral argument shall be directed only to the question of whether the proposed penalty should be modified. Now, whether the penalty suffices to protect the public fails to take into account that any penalty may be unnecessary, even if unprofessional conduct occurred. Now, Section 2229 requires the board, in exercising its disciplinary authority, to prioritize public protection and physician rehabilitation when not inconsistent with public protection. The statutory priorities necessarily contemplate situations where a physician has committed unprofessional conduct, but then has demonstrated sufficient rehabilitation such that disciplinary action is no longer necessary to protect the public, and of course would do nothing to rehabilitate the physician. Now, in some situations, it may even be an abuse of discretion to order discipline when any discipline does nothing to protect the public or rehabilitate the physician because the physician is rehabilitated from the underlying misconduct already. Therefore, the proposed penalty should be modified is the proper framing, not whether it suffices to protect the public. Now, we argue that the proposed discipline of a public letter of reprimand, or PLR, is unnecessary and does nothing to protect the public or rehabilitate Dr. Ng because he has demonstrated rehabilitation from the underlying conduct already. He's already taken 3 board-approved courses. Accordingly, the ALJ's proposed $19,000 cost recovery should also be reduced based on the Zuckerman factors. Now, because Dr. Ng admits he committed unprofessional conduct, the only issue is what discipline, if any, accords with the statutorily mandated priorities. Now, the accusation's charges of unprofessional conduct in this matter are based entirely on Dr. Ng's failure to document and maintain adequate and accurate medical records, and he acknowledges this. He has expressed remorse and demonstrated rehabilitation, as he will discuss in his statement in a moment. Now, complainant nonetheless argues that Dr. Ng must demonstrate rehabilitation for matters not contained within the charges alleged. For example, complainant argues in a written argument that respondent has not demonstrated understanding of how serious violence in the relationship with CP, confidential patient, could affect his medical judgment. This is a diversion. The charges do not critique Dr. Ng's standard of care, nor do they align with the complainant experts' opinions beyond the documented charges. Now, the complainant also writes that the respondent is still failing to acknowledge the role he played in the toxic relationship. Now, this is both inappropriate and irrelevant to the professional charges at hand. Such an argument unjustly intrudes upon Dr. Ng's privacy and strays from the pertinent issues. We urge the panel to disregard the complainant's extraneous arguments that appeal to matters that are prejudicial to Dr. Ng. We urge the panel to instead focus on the accusation's charges and the copious evidence proving that Dr. Ng has successfully rehabilitated from his misconduct. Finally, and And to this end, I remind the board of its duty to give the ALJ's findings of fact great weight. Notably, the ALJ found that there is no likelihood that the conduct will reoccur. Dr. Ng took responsibility early on, the age of the case, established he is safe to practice, etc. And now with this background, I now present Dr. Ng, who will convey his experiences, his corrective measures that he's undertaken, and that why it's not necessary for public protection to give him any kind of disciplinary action.
Good morning, esteemed members. I'm Dr. Zon Ang. I've been a devoted board certified internal medicine physician for 22 years. Today, I come before you with humility and respect for this process to share a reflective journey through a challenging period in my life. I hope to convey the lessons I've learned, the concrete steps I've taken towards personal and professional growth, and accountability in my medical practice. I'd like to begin with some essential context. My husband immigrated to the United States in late 2013, and prior to our marriage, we maintained a long-distance relationship for over a decade. During this period, he candidly shared his medical history with me, and I would observe his medication whenever he visited. I was aware that he had been under the care of Australian doctors for his severe bipolar disorder, PTSD, anxiety, and panic disorder since he was 19. When he permanently moved to the United States, he brought his Australian medical records and prescription bottles. After thoroughly reviewing his medical records, I assumed the role of PCP to continue his medications, including alprazolam, to prevent any potential destabilization. Initially, I intended this to be a temporary until my husband established care in the United States. However, struggles to adapt life in Los Angeles exacerbated his mental illness. And because my husband had trauma-based distrust of mental health professionals in Australia, he opposed my attempts to find new doctors for him. Feeling compelled by necessity and desperation, I continued to oversee his care, hoping to bridge the gap until he could find help he needed. Unfortunately, what was intended to be a short-term arrangement stretched into years. While my actions stem from both love and concern for his well-being, I regretfully neglected to maintain adequate medical records, a lapse in professional judgment for which I hold deeply remorse. With regards to Paul's alprazolam prescription, I attempted to transition him to other medications such as clonazepam and lorazepam, but reverted to alprazolam due to its ineffectiveness. Regrettably, I failed to maintain thorough documentation of my treatment decision and rationale. I acknowledge this oversight and sincerely apologize for it. My focus was solely on my husband's well-being and continuity of care. During the period, my husband began exhibiting symptoms consistent with ADHD inattentive subtype. I prescribed Adderall treatment to aid concentration and focus. However, effectiveness declined over time, prompting discontinuation. I recognize my oversight in not documenting these changes properly. My husband turned to alcohol in an attempt to cope with his new environment and psychological pain. And unfortunately, this dependency resulted in aggressive outbursts, including an incident that left me with a retinal detachment requiring 3 surgeries. Sorry. Moreover, during numerous severe manic episodes, he would have physical outbursts that presented situations where I had to defend myself. Though never an instigator amidst his health challenges, I regretfully avoided reporting the severity of these incidents, not wanting to jeopardize his well-being and force him to be mentally hospitalized and worse yet be deported back to Australia. The experiences has taught me that treating family poses unique risks, primarily the blurring of responsibility essential to ethical medical care. Corners were cut regarding my obligation to maintain adequate and accurate medical records, even for a family member. While family intimacy can influence care, my lapse stemmed from failing to uphold the same standards of professionalism I apply to all patients, specifically medical record keeping. Medical trust relies on professionalism and ethical principles.
Critical documentation is integral to this profession and helps to ensure continuity of care. While my spouse consented to my care, that didn't absolve me from my professional responsibility to keep records of that care and that I obtained consent for his treatment. Today, I stand before you accepting full responsibility for my lapse in maintaining proper medical records. As a medical professional, I remain dedicated to upholding the highest ethical standards and prioritizing the well-being of my patients. Since acknowledging my mistake, I've embarked on a journey of continuous growth and learning to improve my practice against future lapses. My path to rehabilitation has primarily focused on professional boundaries and medical documentation. I have diligently pursued 3 medical board-approved courses: medical documentation, prescribing controlled substances, and medical ethics. I've integrated my enhanced knowledge into patient care, ensuring highest level of quality and safety. Moreover, I actively share these vital lessons with rotating medical students and residents from UCSF, as well as nurse practitioners under my supervision, fostering a culture of continuous learning and excellence with the goal of ensuring that others do not make the same mistake that I did and that they recognize the increased challenges that treating family members can present. My commitment to improvement and accountability was recently honored when my peers nominated me for the Above and Beyond Award in 2023. This recognition served as a testament to the dedication I bring to my role each day and the unwavering standard I uphold. In light of my dedication and contribution, I've been promoted to the role of center lead physician, a responsibility I humbly accept as I continue to strive for excellence. My dedication to medicine and the communities I serve remains steadfast, extending beyond personal growth to tangible contribution within the medical profession. Regarding my resignation from the medical staff of UCSF during pending peer review in 2021, it was a decision reached after thorough contemplation and consideration of various factors. Originally anticipated to be a brief hiatus as an attending physician, the prolonged duration of the suspension from the medical staff of over 1.5 years, exacerbated by the impact of the COVID pandemic, prompted a pragmatic reassessment. With my appeal process still pending and a prospect of further delays looming, the decision to resign was made with careful consideration of time constraint and financial pressure. The primary motivation behind this decision was a strong desire to return to the front line of healthcare, particularly amidst the ongoing challenges posed by COVID-19 pandemic. Resigning from UCSF allowed me to re-engage in a clinical environment where I could apply my expertise, skills to directly benefit patients rather than remain sidelined in prolonged uncertainty. Since transitioning from UCSF, I've had the privilege of serving as a physician at Unlock, a nonprofit program of all-inclusive care for the elderly, also known as the PACE organization in San Francisco. This program, funded by Medicare and Medi-Cal, focuses on providing comprehensive medical care to our vulnerable elderly population. In my role as a physician at Unlock since 2021, I've embraced opportunity to deliver essential medical services to our fragile, underserved geriatric patients community with a commitment to preserving their independence and dignity. Furthermore, I've taken on the responsibility of educating and nurturing future medical professionals, imparting to them the value of geriatric care and the ethical principles integral to our profession. In conclusion, I wish to reaffirm my action, both past and present, have been driven by a profound sense of duty and a steadfast commitment to enhancing patient care. The decision to care for my husband comes from a place of necessity and desperation, an experience I wouldn't wish upon anyone. These experiences serve as a pivotal chapter in my ongoing journey within the medical field. Each subsequent step I've taken since the time underscore my dedication to continuous learning, ethical practice, and unweaving accountability to my patients and the broader medical community. I'm deeply grateful to the board for considering my path towards rehabilitation, a journey that has been both humbling and enlightening. I respectfully urge the board to consider the remedial action I've undertaken and recognize that I do not threaten public safety. I am happy to share that my husband has since found a trusted physician and his mental health has remained stable for several years. I no longer provide him with medical care, and I'm committed to never being placed in a similar situation again. My greatest concern lies in the potential impact on my ability to continue serving at ONLOC. Any restriction on my medical license could jeopardize my position, prevent me from supervising nurse practitioner, and negatively impact the ability to treat Medi-Cal and Medicaid patients. The administrative law judge's proposed decision acknowledged the progress I've made in my rehabilitation journey and recognized that harsh discipline against my license was unnecessary for public protection. I assure the board members of my unwavering commitment to maintaining excellence and integrity in my practice and documentation for my patients, contributing positively to the lives of those under my care and the advancement of the medical profession. Once again, I extend my sincere gratitude for your time, consideration, and understanding. I hope that I have proven my rehabilitation and that further discipline of my medical license is unnecessary. I plead with the medical board to allow me to continue to serve the patients at ONLOC, armed with invaluable knowledge and insight gleaned from the challenges and growth of recent years. Thank you.
Thank you very much, Dr. Ung. Ms. O'Carroll, now you will have 15 minutes for your opening argument, and that time starts now. Thank you.
Yes, Your Honor. Initially, I'd like to just invite the board members, if at any time I'm not loud enough, or you can't hear me, or I'm speaking too quickly, please shout out if that's okay, and I'll slow down and speak louder. So right off the bat, I'd like to address first Mr. Firestone's claim that the allegations unjustly intrude onto the respondent's personal and private life, and his suggestion that his relationship with his spouse patient is somehow irrelevant to the claims before us. This is something I'd like to dispose of that entirely, because we need to recall that it was respondent himself who mixed the personal and the professional, and that is the very basis for the board's discipline. Physicians, in their requirement of being honest and objective and ethical in their practice, must maintain boundaries. And the fact that Dr. Eng did not do so is exactly why he's before the board. And to claim, therefore, that the relationship with his patient spouse is something that is irrelevant or the board should not consider is simply incorrect. It makes zero sense. I think it's also significant to recall that that was one of the bases for discipline. And in fact, one of the reasons that the board's expert properly pointed out there was a departure from the standard of care. The fact that respondent's relationship with his spouse patient was an out of control and tumultuous one in which there was substantial violence between the two of them is simply grounds to show how very unprofessional it was for respondent to take on that kind of a dual relationship. So that is the heart of the case. And I think we need to dispose immediately of the idea that the board cannot or should not consider these facts. It's distasteful and unpleasant that the board has to consider them, but it is in fact a necessity. And the reason for that, I think, should be self-evident by this point. For example, the fitness and the ethics of a physician to treat how they treat one patient, the family member, is relevant and important to how they may behave in another setting. For example, when a respondent became so enraged and upset that he bit his spouse and yet continued to be prescribing controlled medications to him, it's something that the board should recall, because what if a respondent were to be faced with a confrontational or distressed and upset patient in another context? So it is impossible, due to respondents' own actions, to separate the personal and the professional here. And with that said, I think it's also important to begin by acknowledging that the main facts of the case are in dispute. There was, in fact, gross negligence found in this case, not repeated negligence, not simply medical record keeping. The administrative law judge's decision makes quite clear what we have here is gross negligence. Now, where the board has requested information and argument as to whether or not the public reprimand is appropriate in the case, that's where I think we need to consider the fact that the ALJ found that the evidence in this case showed a singular episode of misjudgment with a single patient. Let's bear in mind that that singular episode of misconduct extended over 6 years. So that is something that the board really needs to consider, that it was not a one-off. It was not a case of, a person maybe had a moment of weakness, or, their spouse needed something, or maybe they were even far away and somebody broke their arm, and you give them a quick prescription for Norco or something. That was absolutely not the case here. So we need to distinguish it from those more simple instances where the board in the past has appropriately shown proper judgment and leniency. The fact that this lasted for so long, and the fact that the kinds of medications being prescribed were not small amounts. I mean, we're talking very, very large amounts of benzodiazepines. And as Dr. Eng just acknowledged in his statement before the board a moment ago, he also prescribed and introduced the a Schedule II drug, the ADHD medications. So prescribing not just 3s and 4s, but also Schedule II drugs in combination in high amounts over a period of 6 years is a very serious event that the board absolutely needs to take seriously. Now, the question then would be whether or not Dr. Eng has shown sufficient acceptance and rehabilitation. And I think it's axiomatic, and the board members appreciate that any kind of rehabilitation starts with acknowledging and accepting what it is that you did wrong. To the extent that a person doesn't admit or acknowledge or minimizes what it was, the violation at question, then rehabilitation cannot even begin. And that, unfortunately, is what is happening here. Dr. Eng, to this day, and even before the board now, contends that, and frequently throughout the hearing, contended that his actions were necessary and unavoidable. Now, those are the two important words I'd like the board members to consider. If your acts are necessary and unavoidable, you're not acknowledging that you did something wrong. And even to this day, and even during a hearing, when we'd asked Dr. Eng, well, now that this, your patient's spouse has, now hopefully just spouse, has done so much better now that he's gotten care from professionally trained, board certified psychiatrists, they've adjusted his medications, do you now acknowledge, with the benefit of hindsight, that, you should not have been continuing to prescribe for him for so long? Dr. Eng's response at hearing was, there was nothing else I could do. When he was asked, well, do you realize that your actions put your patient at risk, not just your spouse, but your patient professionally at risk? He said, no, he never put him at risk. And now that passage is cited and referred to and even quoted in the brief I presented. I'd like the board members to consider that carefully, and whether those are the statements of a person who realizes that he made a major professional mistake. And of course, relevant to that is the fact that respondent never voluntarily, like if, for example, if respondent had said, you know what, this is not going well. I'm involved in frequent violent physical contact with somebody who's supposed to be my patient. I need to step away from this, fess up, at least stop it before it goes any further. Then the board would be in a position to say, wow, yeah, that was a terrible situation, but you've now acknowledged what you did was wrong. But that's not even what happened here. What happened was the medical executive committee found out about it because the patient's spouse, his primary care physician, suspected further domestic violence and referred the matter. And then they needed to prescribe another actual, pain medication, controlled medications, and realized that the patient's spouse had been prescribing to him large amounts of controlled substances for the last many years, several years. So that is, then his privileges were prescribing he was no longer able to prescribe. So as a result of that, things changed. So I do think the board should bear in mind how very serious these acts were, how many of the statements that respondent made during his hearing did not acknowledge what went wrong, how he could fix it. And so that ultimately leads the board to the question you're faced with today is what should happen going forward? Now, the arguments that, that Mr. Firestone were making that probation would serve nothing and not do anything for anybody and it would just be punitive, I'd like to address that. Because sometimes it's very obvious and very straightforward and plain what the purpose of a probation would be and why the board needs to, like, for example, if alcohol is involved, it's quite clear. You have a person being evaluated for testing, whether or not biological fluid testing over a period of years. And if they're clean all that time, it's obvious. But something that is a little more nuanced, and I think the board does not always advert to as frequently because it's not as necessary as one like here, which is that if a public reprimand is provided, or if the board chooses to think, you know, gross negligence is not anything we need to address, let's say they completely dismiss the case. If that was to happen, it means that the board has fully drawn a line under all of this conduct. Meaning that if anything were to happen next year or in the future, let's say the police are called again to the house, or there's some question of whether a respondent may have been altering medications of his patient spouse, even in what he claims is an emergency, all of that will be viewed fresh with a clean slate, as if nothing had ever happened before. Now, we've seen instances in the past where, you know, even a prior disciplinary action is cited or listed as a disciplinary consideration. Right. So there, if a new charge is brought, you still, if there's no probation pending, then that means that the board has the obligation to prove that new conduct as if nothing had ever happened before. And only then after they prove it by clear and convincing evidence does the board get to consider, well, you know, this has happened before. That's different from when a physician is on probation. If a physician is on probation, the standard to prove anything new is much lower. It's a preponderant standard, and it's treated as part of the ongoing concern and circumstances as the original grounds in the accusation. So the reason I bring that up is that in this case, if the board does not impose probation, even for a period of a few years, and something was to happen regarding respondent's judgment in the next couple of years, it would be for all extents and purposes legally as if he had never had any prior action before the board. And that is something the board needs to consider. Is the board sufficiently convinced that this 6-year event of gross negligence was sufficiently mitigated, or respondent has been so rehabilitated that it is willing to draw a complete line under it and consider it almost to as never have happened should anything new go on in the next several years? I would argue that given the fact that respondent to this day does not acknowledge what he did and that it was his choice and he was protecting himself, putting his own interests above that of the patient, the fact that he still does not do that, I would suggest to the board that it really is wise to impose a period of probation, which of course is in accordance with the disciplinary guidelines. And on that, I would submit the matter.
Thank you very much, Ms. O'Carroll. All right, and now respondent will have another 5 minutes for closing arguments. Mr. Firestone, your 5 minutes starts now.
Thank you, Your Honor. I urge the panel to recognize the shortcomings in the DAG's arguments that she just made and what she made in her written submission. Her approach seems to complicate matters unnecessarily and could unfairly bias the panel members by introducing irrelevant facts not pertinent to the accusation's charges. All you got to do is look at the accusation. There's 3 causes for discipline in the accusation. All of them are related to documentation. There's nothing about a police being called or his prescribing practices or the dosages. There's nothing about that. There's no accusation or allegation that those were below acceptable standards of care. So she's talking about stuff that's irrelevant to what's in the accusation. It's crucial to note that the accusation does not claim that Dr. Ng's treatment of his spouse, including prescriptions of controlled medications, failed to meet the standard of care. This was neither alleged by the complainant in the accusation nor supported by their expert's testimony. Dr. Ng's sole oversight was in his documentation and record maintenance. He acknowledges this misstep, and he has since undertaken comprehensive remedial education in record keeping, prescribing practices, and professional ethics and professionalism, affirming his commitment to the standard of medical practice. Now, it's beyond the board and the DAG's jurisdiction to assess the nature of Dr. Ng's personal relationships or assign blame therein. She keeps calling it a toxic relationship or a violent relationship. It's irrelevant to what's in the accusation. The allegations of the accusation are focused on documentation issues. Well, all three causes for discipline. Even the medical board's expert, the complainant's expert that reviewed the case, had no criticisms of Dr. Ng's treatment of his husband, other than he needed to document. I would like to again remind the panel that pursuant to the mandates of Business and Professions Code 2335, subdivision C1, the board is obligated to accord substantial consideration to the ALJ's factual findings. The statute clearly stipulates, when considering a proposed decision, the board or panel shall give great weight to the findings of the administrative law judge, except to the extent that those findings of fact are controverted by new evidence. And there is no new evidence to controvert those findings of fact. So the board should give great weight to what was in that 52-page detailed decision by the ALJ. Now, the findings by the ALJ that Dr. Ng will no longer treat CP or any other family member, and that there's no likelihood that the conduct at issue in this case will ever occur again, is found in the legal conclusions, although it should be a finding of fact, considered a finding of fact. Now, the ALJ found that Dr. Ng's failure in record keeping was a singular episode of a lapse in judgment, influenced by his spouse's severe mental health challenges and not reflective of his overall professional ability. The complainant's stance lacks empathy and overlooks critical mitigative factors that are crucial for a balanced evaluation of this case. The panel should recognize Dr. Ng's genuine remorse and his proactive steps toward rehabilitation. Now, the whole issue that the DAG raised about needing to put him on probation just in case he might have something in the future is not a valid basis for putting somebody on probation. There's no public protection purpose for putting somebody on probation. That's not a valid basis to put somebody on probation. Now, as the ALJ's proposed decision reminds us, rehabilitation is a state of mind, and Dr. Ng's situation, compounded by the pressures of caring for a loved one with severe mental illness and resistance to care, underscores the need for empathy and understanding from the Medical Board of California. And these should credit Dr. Ng's efforts to correct his mistake and the positive testimony on his behalf. Now, I urge the board to review the testimony of nurse practitioner Allison Riley, which the DAG even cited, whose insights further illuminate the intricacies of this case and Dr. Ng's professional character. Her testimony, particularly under cross-examination, underscores the necessity of viewing Dr. Ng's actions within the broader context of what he was dealing with and the personal dilemmas healthcare providers often face. And her testimony begins on transcript, page 99 through 139.
30 seconds remaining.
In conclusion, Dr. Ng's acknowledgement of his errors and his rehabilitation journey reflect his dedication to medical care, and I urge the board to consider these factors. And thank you for considering the broader implications of this case and Dr. Ng's continued capacity to serve the patients with care and professionalism without further discipline. Thank you.
Thank you very much, Mr. Firestone. And Ms. O'Carroll, you will also have 5 minutes for closing argument, and that starts now.
Yes, Your Honor. I'd like to start with the last thing that Mr. Firestone said. He said he was seeking the board's empathy and understanding for caring with the person with mental illness. So right there, he's asking the board to go beyond the four corners of the accusation to take into account personal matters, personal stressors that respondent was facing at the time when he claimed he was so concerned for his spouse that he needed to prescribe to him for 6 years. My point is that either the board views the entire case in a vacuum and says, we don't know anything about these individuals or care anything about their relationship. We're looking strictly at what happened. And all we know is some person prescribed to another person who was their spouse for 6 years. Or else the board considers both arguments. One, that the patient had a very complicated and severe mental illness. Or two, and in addition, that there was a very tumultuous personal relationship going on between the two parties, the spouse and the patient. So what I'm suggesting is that it would be unfair for respondent to say, have his cake and eat it too. You can either look at the matter in a vacuum, or you can look at both sides of the case. And both sides of the case are what respondent is asking the board to look at, and so that's what I'm asking the board to look at as well. The fact is impossible to ignore that the administrative law judge gave considerable leniency and agreed, and is explicit in her proposed decision that she recommends departing from the disciplinary guidelines. In other words, not doing probation because of sympathetic factors that she had for a respondent. His statement that he really needed to do this and he could not help himself, it was to help his patient. So if the board is going to consider that and not propose probation as would be required by the disciplinary guidelines, then the board also needs to consider the negative side of that personal relationship, which was that the two of the patient and spouse and physician ended up causing each other severe physical injury, sending each other to the hospital and requiring surgery and having the police called on many occasions. So these are both the positives and the negatives. And of course, as respondent concedes essentially by so arguing, it's something the board must take into consideration because the very basis of this case is that respondent made the decision to mix the personal and the professional. That is the whole basis for the departure, to the extent that he would be entitled to leniency because he was in a difficult spot dealing with a patient who he was very concerned about, is exactly the same reason that the board needs to consider that respondent disregarded his professional objective requirements to refer this very troubled patient to objective board-certified psychiatric medical care, which finally happened when the medical executive committee stepped in, and consequently the patient is doing far better now, and according to respondent, their relationship is also better. That's not a coincidence. That's why the rules of professional conduct, that's why the Business of Professions Code exists. You know, that they did know something, the people who contributed to and drafted this. They knew how important it was to keep the personal and the professional separate. That's not what happened here. In light of all the facts and circumstances, the public needs the level of protection that involves monitoring respondent, not drawing a complete line underneath this conduct and moving forward as though it never happened. That would not be the appropriate outcome here. To the extent that Mr. Firestone contends that the idea of being able to monitor somebody on probation is that probation does not serve the public interest or safety. That would completely disregard the reason probation was created. Obviously, the purpose of probation is a judge, or in this case, the board, deciding that the conduct was sufficiently serious, that we're not going to draw a complete line under it. We're going to take a wait and see approach and make sure that thank you. Over the next couple of years, we have the ability to address this again should the problem not be completely have a line under it. And with that, I will submit it.
Thank you very much, Ms. O'Carroll. All right, so the respondent has already addressed the board. However, I do want to give board members an opportunity to ask questions. So Dr. Ng, as you continue answering the board members' questions, I'll just remind you that you're still under oath. Do you understand that, sir?
I do.
Thank you very much. All right, I'm going to ask each board member whether they have questions. I'm going to start with Dr. Thorpe. Do you have any questions for the respondent?
I do, Your Honor, but I would defer to my colleagues first, and I'll ask at the end.
That's perfectly fine. I'll circle back to you. Dr. Heltzer, do you have any questions for the respondent?
I have no questions. Thank you, Your Honor.
Thank you very much. Ms. Lawson, do you have any questions?
I also have no questions. Thank you.
Thank you, Ms. Lawson. And Dr. Mahmood, do you have any questions for the respondent?
I don't have any question this time. Thank you.
Thank you. And then so I'll take out back to you, Dr. Thorpe. Sounds like you did have some questions, so go ahead whenever you're ready.
Thank you, Your Honor. Dr. Ng, I do have, so the real concern for I think for the medical board is how do we protect the public going forward? If we don't initiate some form of disciplinary action, how can we be assured that the public is protected going forward? And how can we be assured that you truly are rehabilitated? It's fine to say you're rehabilitated and that you do say you're sorry. That's fine. But what really matters is, especially since there was a very long period of time that you were in this behavior and kind of ignoring the principles of ethics, how can we be assured that this won't happen again? And is there, I'm not sure there is a way. That's what's concerning.
Firstly, I'd like to address what the DAG said. It is not true. As soon as we moved to San Francisco in 2017, I, using my UCSF connection, got my spouse a psychiatrist as well as a PCP, not UCSF executive board. Unfortunately, he had a very hard time with those two physicians, and he didn't really trust them. He felt that the two doctors were not very LGBTQ. They didn't know much about LGBTQ issues, and more importantly, his PCP used a scribe, and that really turned my husband off because he really felt like he was.
Dr. Ng, you're not answering my question.
And also, firstly, Paul is very, very stable. He is now cared by a team of psychiatrists.
I appreciate that. That's not the answer to my question. I'm sorry to interrupt you, but we do have a limited amount of time. How can this board be assured that you are not a danger to the public and that there will be no further evidence, or that we won't have to come back in 3 years if we don't discipline you, that we won't have to come back in 3 years and that we'll have to start all over again? How do we know that?
It's been 5 years since this happened, and after I left UCSF, I started practicing medicine. I'm doing great. I'm doing some really good medicine. There's no reason why I would ever want to prescribe for Paul. I've learned my lesson. There's no way I would ever treat a friend or a family member, and I'm making that vow. I have learned this valuable lesson. And, I just will not do it again. I have learned a lot.
Thank you.
Dr. Mahmood, can I ask one?
Oh, I'm sorry. Was that Dr. Mahmood? Did you have a question?
Yes.
Yes, please go ahead, sir. If you could just speak into your microphone, because you're quite faint on my end, at least. Thank you. Thank you, Dr. Mahmood.
Dr. Ng, do you realize what you were doing was completely unprofessional, unethical, and was harm to not yourself, but to the society? You equivocally realize that, and you admit that?
Well, when Paul moved to the United States in 2013, he had no job and he had no medical insurance. And he had been taking all the psychiatric medication since he was 19 years old. I felt that it was important. I had his Australian medical records. I had his pill bottle. I felt that it was important for me to help him to prevent a destabilization.
For how long?
I started in LA, and we lived in LA for about 3 years. When we were in LA, I tried to get him a psychiatrist, and he adamantly refused. Again, I was left, Paul was very, very sick, and without those medication, he would have ended in a psychiatric hospital. I felt comfortable treating him because I knew his medical history. I had his medical records. Those medications I didn't just come up with the dosages. I basically prescribed whatever he was taking from Australia.
This thing goes on for years, and you would think that you're the only one who knows, but his problem is that nobody else can know, and you cannot get him any help from somewhere else and not do the professional thing. My question was, what were you doing? Do you admit that was unprofessional, unethical, and not up to the standard of care to save Californians? That's my question is very simple.
What was unprofessional of me was that I never kept good medical record. I felt that it was really important for me to help Paul because without those medication, he would have gotten really, really sick. And I made several attempts to get him a psychiatrist in Los Angeles. I even made, so many attempts when we moved to San Francisco. It's really hard having to deal with someone who has bipolar. And may I share something about about my spouse with you? He also has a strong mistrust of physician because he was a victim of rape trauma, and he was also a victim of hate crime, and he was beaten and he suffered fracture. And there was once in Australia, after he got raped, he went to the emergency room and he could hear that the doctor was laughing at him and made him felt like he was responsible for his sexual trauma. And because of that, Paul was really adverse to going to any doctors. And so I felt that it was important for me to reach out to help him as a doctor.
Okay.
It was never my intention to, it was never my intention to be his primary care. I do not think that I am more qualified than a psychiatrist to take care of him. I just needed to help him.
I have one more question on just on your statement. You just said that you learned your lesson that you will never treat a family friend or a family or friend again. I am kind of lost right now. From all these things, you learn this, that you should not treat your family or friends, or you should treat them in a standard care, where you can be able to help. Well, we are all trained, we are physicians here, 3 of us are, we know you can have some family members come to you, your friends come to you, but we need to keep
I'm sorry,
the
doctor,
standards.
please speak up.
So the learning the lesson that not treating family or friend is, I think, not getting anywhere. To learn how to treat everybody on a professional standard of care, which the guidelines, medical board or state of California gives you, that is where we need to come up, and that kind of little bit concerns me.
Agreed. I took a medical ethics class, and what I learned from that course and the take-home message is that taking care of family members and also friends can sometimes cloud your judgment. So I really feel like in order for me to be an objective doctor, I think it's best that I don't take care of friends and family.
I have no further question. Thank you.
Thank you, Dr. Mahmood. Let me make sure I circle back with everyone else in case there's any questions that came up. Dr. Thorpe, anything else from you?
No, Your Honor. No
Thank you.
further
Dr. Heltzer?
No, Your Honor. Thank you.
Thank you. Ms. Lawson, anything from you?
No questions, thank you.
Thank you. And Dr. Mahmood, are you satisfied?
Yes, thank you.
Thank you very much. All right, then, that concludes the arguments in this matter. The record is closed. The case is submitted for decision, and we are off the record in this matter. The panel will be deliberating in a closed session. Dr. Thorpe, I will turn it over back to you to conclude the meeting or continue the meeting as you see fit. Thank you.
Thank you, Your Honor. I appreciate your help, and we appreciate the presence of the DAG as well, and the court reporter. Thank you all.
Thank you.
Judge Van Roon, we will be opening up that other session you should have the invite for, but if you need anything from the court reporter, now would be the time to get it. So you won't be joining us in the closed session.
Perfect. Thank you so much. I will sign into that. I don't believe I fill out a court reporter form since the board